Hello, this is Mel Thompson, and this is a podcast, and a series of podcasts about political risk. Today we'll be discussing Argentina, more or less in a historical sense, trying to give you an idea of the type of problems that are faced by the foreign direct investor or company looking to do business in Argentina, particularly in the area as associated with the risk of expropriation. Above and beyond any agreement, it must be noted that the Argentine government has a history of simply not following the rule of law as it pertains to expropriation. Now, Section 17 of the Argentine Constitution specifically addresses the issue of expropriation. It does so under the right of private property and states that any expropriation must be authorized by law and be previously compensated. In practice, this has not always been the case. Now, for example, in December of 2001, the Rodriguez Sa administration defaulted on a $132 billion debt. This was a public debt. This was after a 3-year spiral of economic woes. So the problems within the economy led to a political decision to default on a debt, and that in itself is the actual expropriation. In 2012, the government of President Cristina Fernandez de Kirchner expropriated 51% of oil and gas company YPF from Spanish-owned Repsol. Now, a settlement with Repsol was achieved and approved by the Argentine Congress on the 23rd of April 2014. But still, the fact that this happened again and again and again is a very, very worrisome problem if you look at the overall history of Argentina and why it's very important to understand what you're getting yourself into. There is no doubt that Argentina is a great place to be a foreign direct investor or a company doing business. However, you need to know what you could possibly expect. This is no longer a stigma attached to political decisions in this country. If you default on a public debt, or you decide you're going to take over a particular property of an investor or a company, it is no longer viewed in Argentina as a really horrible thing to do by the people when it comes to their opinion of politicians. To a certain degree, it's almost expected. Now, those two examples that I gave are notable, and this is not these aren't the only two examples that you could possibly find. They're just fairly notable because they show a pattern over a period of a decade, a little more than a decade, of what could happen. The fact that they were so large within a period of about 11 years should give any foreign direct investor a certain degree of pause. You need to have insurance. You need to have due diligence. You need to be prepared. Just because you have a bilateral investment treaty does not always mean you're protected. And this is where we get to the crux of this particular podcast. It's more than just having a treaty or insurance. It is also about the language in contracts. Contracts can also ensure, or at a minimum, mitigate the political risk of expropriation, particularly if you insert clauses in there that internationalize the agreement. In other words, put it under international law. These are very, very key elements of mitigating the risk of the political risk of expropriation. Internationalizing contracts, bilateral investment treaties, and insurance. These are things that can never be taken for granted. They all must work in concert, hand in hand, and they cannot be utilized as just separate vehicles to protect your foreign direct investment or your company. They all work together. I cannot stress that enough. This has been Mel Thompson.